Good afternoon, everyone. So this is part two of the Media Conglomerate lecture. So one thing that I want to quickly go back to quickly, because we ended up talking about copyrights. And one thing I forgot to mention when I was talking about copyrights, but what was the length of a copyright during the Copyright Act of 1976, which didn't start until 1978. So the Copyright Act in 1976 for an individual author at the time was a lifetime plus 50 years. So again, copyright for an individual author under the Copyright Act of 1976 was lifetime plus 50 years. And the length of a corporate author, it was 75 years from publication or 100 years from creation. So 75 years from publication or 100 years from creation. And so again, the reason that you have different dates for corporate authors is sometimes they write a script or produce content, but they don't necessarily publish it or release it to the public. They keep it in a vault, or they just hold on to it for whatever reason, and then they go on to publish it later. So that's why you have different dates for the corporate author. And again, these copyrights under the Copyright Act of 1976 were extended under the Sonny Bono Term Extension Act that happened, I believe, in 1998. So one thing I did want to talk about regarding copyrights is that copyrights can be really tricky, and especially in the area of music. So this is an example of a copyright case that's currently happening. Just actually got settled. I think it got settled. I'm not sure. Katy Perry initially lost the first part of this case, but I'll show you the video. It just sort of discusses the issue between Katy Perry and I think it was Dark Horse.
Katy Perry arrives at a Los Angeles courthouse wearing a mint green power suit. The pop star is accused of plagiarizing the underlying beat in her big hit, Dark Horse, from 2013.
Katy Perry just took the stand here at the federal courthouse in Los Angeles, where she explained her process for writing her music. Gospel rapper Marcus Gray, who goes by the name Flame, is suing her for copyright infringement. Perry was all business. She made eye contact with the jurors and even offered to sing her song live when a technical glitch briefly prevented them from playing it.
Listen to the beat from his song Joyful Noise. Now listen to Katy Perry's song. The case is being compared to Robin Thicke and Pharrell Williams, who were ordered to pay $5 million to the family of Marvin Gaye in a copyright infringement suit involving blurred lines. Now Katy Perry is facing her own legal battle.
So anyways, Katy Perry ends up losing the initial case. And then Katy Perry's lawyers appealed, and now she recently just won. So now she doesn't have to pay the artist, to I think Dark Horse, for plagiarizing the song. So it's sort of, if you hear the song, I mean it's tricky. Katy Perry's defense at the time, and I think still is, that she never heard that song. And who knows? When it comes to copyrights, especially when it comes to music, it gets really complicated. So anyways, she lost the first case. She appealed and won the second case. So please remember that, because I might test you on that she did actually win the appeal, and she doesn't have to pay, I don't know how much she had to pay, millions of dollars to the other artist, so for plagiarism. Anyways, let's move on to talking about trademarks. So as you can see here, there's on the slide, trademarks, you see the TM and you see the R with the circle. The R with the circle is the actual official logo of what is a trademark. So if you ever see a circle with an R, that is the official trademark. Please do not forget that, because I might just quiz you on that as well. So trademarks were enacted essentially under the Lanham Act, as you can see here. The Lanham Act took effect literally right after World War II, as it became very apparent to our government that the idea of logos and names and phrases and symbols and those sorts of things were going to be immensely important post World War II. And so they placed this act to essentially protect slogans, names, phrases, logos, and symbols, as you can see here. Now, one big difference between a trademark and a copyright is that a trademark lasts forever, right? The name Mickey Mouse or the name Walt Disney Company, it's been trademarked, the name. And so that name will last forever, right? As long as there's a United States. And so that being said, it has to be renewed every 10 years. So it lasts forever, but it has to be renewed every 10 years. So please fill in that question mark, 10 years. Now, that being said, the very first time that you're going to renew a trademark, it has to be renewed between year 5 and 6 for the first time. It's called declaration of use. The reason that the trademark office does this is that essentially you have to prove that you're still actually using the trademark, right? It's what happens lots of times, unfortunately, in the United States is that people start up businesses and they fail and they no longer use that trademark. And so that's the reason why the trademark office essentially forces people or organizations to renew their trademark between year 5 and 6, is that they want to make sure that the trademark is actually being used. And so essentially a trademark limits how and who can use a trademark. And so the trademark thing is very important for companies. Most companies nowadays are very protective of their marks. It's incredibly important. So on this slide, they're going to explain a little bit more about trademarks.
Is a distinguished sign, like a word, phrase, symbol, or a combination of these elements. A mark is used in business to indicate the source of the brand, in order to distinguish and identify it in the market. Trademark protects the customers by preventing the public confusion as to the origin or quality of a product. In addition to rewarding the brand owner by maintaining his business' successful reputation. Unlike most countries, the American law protects a brand, even if it's not registered, which is known as the common law trademark rights. As the trademark ownership belongs to the first seller, who use and trade the brand in the market. A trademark infringement could happen when a likelihood of confusion exists between trademarks, which means that the brands are very similar, that consumers would mistakenly believe the two products come from the same source. In this case, the fake brand has to stop misleading the market, and is liable to pay damages to the original brand owner. However, trademark protection is not absolute, as it's subject to certain limits, such as the trademark abandonment, geographic limitation, and the fair use of the brand by a third party.
Now, the fair use of a brand and the third party is a little confusing. Essentially, what it means is that you can actually refer to another trademark, let's say in a blog, or if you're making reference to another trademark when you're essentially trying to describe your particular trademark. Under certain circumstances, you can use a trademark. It's under fair use, but again, you'll probably talk more about this, I would think, in common law. So, because I'm not really an expert when it comes to trademark laws in the United States, or heck, trademark laws in general. So moving on, as a brief explanation, to go back when he was talking about examples of trademark infringements. So the idea of likelihood for confusion essentially means that you create a trademark within the same category. So again, similar trademark, same category. And that's the likelihood of confusion. And so, for example, when I used to work in special events, we created an award show called the Bravo Awards. And so that's fine. Nothing's wrong with that per se, but but it just so happened that there was another Bravo Awards out there, and we got busted for likelihood of confusion, because we created an award show under the same category. In this case, the category was, I think, Latino events or something like that. So they ruled against us, they being whoever the courts were, and we ended up, I think, paying. I don't remember the amount of money, but I think it was. I think it was $25,000 that we ended up being fined. So it was a pretty significant fine for the fact that we were just, a tiny little company, or actually a nonprofit. And so the point that I'm trying to make to you is to be very careful when you are coming up with a name. Make sure that you do your research. Now, what is required of you, and this is what I mean by what is required, is due diligence. So due diligence is required by the owner and the producer of the new label, right? The new trademark. And so we got busted because we didn't do our due diligence, right? So in other words, we needed to do better research in terms of what kinds of names existed in the marketplace before we came up with the name Bravo Awards. So eventually, I think we did end up changing the name from Bravo to, I think they called it Alma afterwards. Anyway, so that's one example of a trademark infringement. The second example of a trademark infringement is a knockoff, or essentially what that means is the counterfeiting of goods. So again, counterfeiting of goods. So I don't know how many of you go to, let's say, downtown Los Angeles, to the fashion district. You'll see a bunch of knockoffs, right? Of, let's say, especially of sports jerseys and of other items as well. But essentially that means that it's not an authentic jersey, right? Produced by a retailer approved by, let's say, the NFL or Major League Baseball or whoever. And so they produced it and put their label on it. And that's why it's the counterfeiting of goods. And so generally speaking, what ends up happening in that particular case is that there could be a cease to desist order. So again, cease to desist order, where essentially the owner of the authentic trademark tells the knockoff people, the people who are creating the counterfeits, to stop production. Sometimes there's also a fine involved as well. Sometimes, I think it depends on the value of the trademark. The next one is dilution. Dilution means tarnish. So that means a similar trademark that dilutes a current trademark. Now, generally speaking, dilution only applies to famous brands or well-known brands. So not any brand can just say, "Oh, they're diluting my trademark, and therefore that's an example of a trademark infringement." That's not the case. It has to be a super famous, or it has to be a well-known trademark for this to apply. So, for example, I know there was a case at one point in time when somebody took a logo of, let's say, Starbucks, and they changed it to something else. It was the same sort of design, but it had nothing to do with coffee. So that would be an example, because obviously Starbucks would be an example of a well-known or famous brand. So again, it only applies to famous brands. The last and simplest, I would imagine, to remember is illegal use of a celebrity's image or name. So you place their image or name on a T-shirt or whatever else, and that's an example of trademark infringement, because a celebrity's image is considered to be a trademark, and so is their name. So market structures. So market structures are going to be really important to remember. Just bear in mind that when I talk about market structures for production, right, is that these companies produce content, right, for specific buyers or for buyer. So let's say there's a market structure of production, again, number of buyers. So anytime you have a monopsony, it means you have a market with just one buyer or producer. So oftentimes when you think of a monopsony, you think about sports leagues, for instance, the National Football League or the NBA in the United States or North America, or Major League Baseball, at least here in North America. So monopsony meaning essentially you have a market with one buyer. So if you're an NFL player and you want to sell your talent, right, to to a professional league, you only have one option, right, the National Football League. So monopsony means only one buyer. And duopsony means that you have two buyers only in the marketplace. So duopsonies really don't really exist in entertainment anymore. Um, when there was Sirius XM in satellite radio, you had an example of a duopsony there. In that case, you had two buyers, right? But obviously they have merged, and it's another a monopsony. Satellite radio is another example of a monopsony. So a duopsony again means two buyers. Oligopsony means essentially that you have a handful of buyers. So, it usually means three or more, 3, 4, 5, 6, 7 major buyers within the industry. And so there isn't that many examples of oligopsonies in entertainment. Outside of maybe theme parks or amusement parks, you only have a handful of powerful buyers. So for instance, like Walt Disney or Universal, or maybe like a Six Flags or a Cedar Fair. There's only a handful of powerful companies or powerful buyers that buy content within that particular industry. So again, oligopsony is a market controlled by a handful of buyers, three or more. Perfect competition. So perfect competition means there's no market control. There's lots of buyers, lots of producers. They produce identical products or perfect substitutes. In the world of entertainment, this really does not exist. So again, in the world of entertainment, this really doesn't exist, at least not currently. There's not an industry, at least not right now, where everybody starts with the clean slate and starts at the same place. That just right now, at least in entertainment, doesn't exist. And some people would say that doesn't exist at all. It's just, it's an ideal, but it doesn't really exist in our society, at least not in the United States. Monopolistic competition, no market control, lots of buyers, lots of producers, slightly different products that utilize branding, advertising, location, quality, real or not, to create differences. There's actually some examples of this, especially if you think about tourism, right? Tourism, there's lots of different places that you can go and vacation. Whether it's going to a specific beach, going to the mountains or the desert, right? And so there's some differences in terms of location and even the way they utilize branding at times. And so that's an example. The idea of tourism would be an example of monopolistic competition. There's some forms of monopolistic competition when it comes to motion picture production. There's lots and lots of movies that are being produced by all sorts of different movie producers, right? And so I want to say there's at least 800 movies that were made, at least in 2020 before COVID hit. And same thing with music. There's lots and lots of different songs that are being produced. So when it comes to production of content, there's really no market control. These producers, whether it's music producers or film producers, are obviously not making the same kinds of music. It might be similar, or same type of film might be similar. And obviously they're utilizing their branding, like the artist's name or their name. They might have the ability to advertise, and maybe because of their name, it's thought of to be higher quality. I mean, is it really? Maybe not. But again, monopolistic competition means there's lots of products that are being that are being produced. And potentially there's also lots of buyers in the marketplace that could buy these songs, right? Or movies. It's not just limited to, the big three record labels, or it's just not limited to the big Hollywood distributors. So distribution. So sometimes who are the major distributors, right? So or another way of thinking about distributors is sellers, right? Who are the major sellers in the industry? So monopoly, right? Who are an example, obviously going back to sports. So sports is considered to be, at least the sports leagues, professional sports leagues, are considered to be a monopoly. They're selling their product. There's only one league. If you think about cable is considered to be local monopolies, right? You only have one choice to buy one, if you're going to do cable, one cable company in one market. That's it. A duopoly means that you have a market controlled by two distributors or two sellers, right? So a market controlled by two distributors or two sellers. Essentially, they control the market. An oligopoly. An oligopoly is a market controlled by a handful of distributors or sellers. Now, this is important in the world of entertainment and even tourism to some extent. Most distribution structures are oligopolies, right? They're controlled by a handful of distributors. So the record industry, although you may have lots and lots of music produced by all sorts of people that are being bought by all sorts of people, at the end of the day, there's three major distributors in music, right? In movie industry, there's only, 5 or 6 major distributors when it comes to motion pictures. Television, right? There's only a few, 4 or 5 major distributors in television that control the industry. So a good way of measuring what is considered to be an oligopoly, once you start doing research for your final paper, or you're just doing regular research, is that you look at the top 4 companies. It's one way. You look at the top 4 companies within that particular industry, and if they control over 40% of the market share, it's considered to be an oligopoly. So let's say the top 3 companies control 45% of the market share. Well, that's an oligopoly. If the top 4 companies control, I don't know, 50% of the industry, market share wise, it's an oligopoly. So hopefully that's clear. And most market structures when it comes to distribution in entertainment and a lot in tourism are oligopolies. Perfect competition, like perfect competition for production, doesn't really exist in distribution either. So perfect competition means there's no market control. There's lots of distributors. They're all distributing identical products, i.e. perfect substitutes. Again, does not really exist in entertainment and tourism. Now, market structures when it comes to distribution. So actually, going back to the idea of tourism in some respects, I'm talking about just thinking about your vacation spots would be an example of monopolistic competition, right? There's lots of places that you can go to go visit, and they're going to advertise their business in a very unique way. If you ever watched the way the state of California advertises the state of California, or the way New York advertises New York, or let's say a country like New Zealand or Australia advertises its country as a tourist destination. All these different places throughout the world advertise their country or their city, and to sort of highlight the differences between their city and other places. So that's an example of monopolistic competition. Another example of monopolistic competition would be in the special events industry. So anytime you're doing sort of a live event or special events, it's very much a monopolistic competition, um, because there's lots of weddings being produced, right? If you think about it, lots of special events that are being done, or lots of conferences that are being done throughout the country and throughout the world. And so please remember again, a couple of examples when it comes to monopolistic competition where you have no market control, lots of distributors. It would be special events / weddings and tourism. Those are two big ones when it comes to monopolistic competition, when it comes to distribution. It means there's a lot of choices, no market control. So one last thing I'm going to talk about when it comes to um, this particular lecture is market research. So market research has become incredibly important within not just entertainment and tourism, but just in general, because the cost to advertise is so incredibly high. And so you want to gather as much information about your public as you possibly can. So anyways, what's the definition of market research? Is to gather data or gathers data that will help an organization sell more products efficiently. So again, sell more products efficiently or produce more money. So again, helps gather data that will help an organization sell more products effectively and or produce more money. And so I gave you some examples there of concept testing. So concept testing, essentially you would get a focus group of folks and you would ask them like, what do you think of this particular idea, right? So for instance, I don't know, let's just say you had 3 single men living together and a baby arrives at their door. Like, do you think that's a cool idea that these 3 men who are just, bachelors now are in charge of raising this baby on their own? So you might like that idea, or you maybe not like that idea. Also, when it comes to focus groups, you might do something called title testing. So title testing essentially means that they'll give you a series of titles and see if any of the titles resonates with you. Ad testing, they'll show you a bunch of commercials and see if you like any of the advertisements. And one last example, and there's many by the way, it would be exit surveys. So maybe you went into a special screening of a movie or a television show, and they'll ask for what your thoughts are about that particular movie, which characters you like, which characters you didn't like, what scenes you didn't like, what scenes were your favorite, those sorts of things. And the whole point of doing market research is that you want to avoid um, a box office bomb, or you want to avoid a financial failure. So again, you want to avoid what they call in the movie industry a box office bomb or just a financial failure. So quantitative research. So quantitative research is most useful when you want to use data, right? Data or numbers at times to formulate facts or uncover patterns. So again, most useful when you want to use data or numbers, right, at times to formulate facts or uncover patterns. So I gave you some examples here of, doing online or paper surveys where you try to, on a scale of 1 to 5, what are your thoughts on a survey? They do face-to-face interviews, which again, they ask for your opinions face-to-face. They do online polls where they ask you some questions and they gather, and based off of these polls, they come up with numbers or percentages, and they also utilize telephone interviews to get this information. Generally speaking, right, this is more structured. It's very sort of robotic or it's not very informal at all. You just want information from the individuals that you're interviewing, and you typically want to get it done very quickly. So qualitative is most useful when you're trying to get an understanding of opinions, reasons, or motivations of consumers. So again, most useful in trying to get opinions, reasons, or motivations of consumers. And examples are focus groups, um, individual interviews, participation, or observation. This type of research is much more nuanced. You really want people to open up to you. Um, you want them, put them at ease. Qualitative takes a lot more time to gather because you really have to go back and sort of try to get an understanding of why people do what they do. And so it takes more time to gather qualitative research. Quantitative research you can gather fairly quickly. Qualitative takes up a lot more time. And also one last thing before I end the lecture for part number one is oftentimes with market research, they also utilize both methods. In other words, they'll do quantitative and qualitative, and they'll do both of them. It's called mixed methods. So it is possible to utilize both types of research to gather data that will help your company again sell more products efficiently and or produce or generate more money.